Congrats on completing this critical first step. Well done. Now it's time to take the next step. Because it's not enough to just list someone as your successor on your insurance application or with the bar. If that attorney must ever step in, how prepared will they be? Think about it this way. If something happens to you tomorrow, would your successor know what to do on day one? Or would they be facing a pile of files, have no access to a calendar full of deadlines, and be left with a lot of unanswered questions that will take weeks, if not months, to fully resolve? That difference comes down to how well prepared they are. So let's walk through how to do that. Start by sitting down with them and having a conversation. Explain what you expect if they need to step in, be it to keep the practice going in the event of a shorter-term absence due to an illness or injury, or to wind down the practice in the event of death or permanent disability. Clarity up front can help prevent headaches down the road. Your successor will also need to know where things are and how your office works. If you haven't already done so, develop an office procedures manual that explains key systems and processes to include calendaring and docketing, file organization protocols, billing and trust accounting, your case management system, and active file list. The goal is to provide a clear picture of how you run your practice, because if everything is primarily locked up in your head, their ability to help your clients will be limited at best. Of course, while knowledge of how your practice is run is essential, it's all for naught if your successor is unable to access key systems, to include your trust account. You can solve this problem by creating a confidential paper or digital document that provides login credentials for key systems, the location of important physical keys, and contact information for your IT provider or network administrator. Store this document along with whatever other documents might be necessary to authorize and enable your successor to access your trust account in a secure physical or digital location. Then make sure your successor knows how to access this information in an emergency. Next, develop and provide sample scripts or templates for client notifications and file transition letters. Your state bar association and malpractice insurer will likely have samples available that can be tweaked to reflect your personal tone. Finally, since systems and processes tend to change and evolve over time, schedule a once-a-year check-in to review and update your plan as necessary. Don't risk leaving your successor in a state of limbo because you never took the time to make sure your plan remained current. At the end of the day, succession planning isn't just about checking a box. It's about protecting your clients, your practice, and your reputation. Naming a successor attorney is the first step. Preparing them is the only way to make sure your plan will work. Have a conversation, provide the roadmap, put it in writing, and keep it updated. Your clients, your successor, and your future self will be so grateful.